Morning, Farshan. Yeah, sorry, afternoon it is. So you could see this session, yeah. So today's session we'll be looking at it's a 2-hour block. Okay, it's like a tutorial, refresher, and an assignment discussion session. Okay, so we'll go through the assignment learning outcomes, what is expected of you to complete them, and we'll go through a little bit, like you said, you wanted me to identify what tort is and things like that. So I'll go through that as you know, as much as I can in regards to what the expectations is for the assignment.
Okay.
Okay. So firstly, we'll start with the tasks. Okay. So in preparation, so this is task 1. And the task is set up in, I'm going to just see if I can share the other bit with you, but I'll go through this in regards to that. Let me share this other part with you. I think it is, let's see if I can open it up. Must be this. Have you got the assignment with you?
Yeah.
It's the assignment that says that you are employed by someone, yeah? This one here? Have you got this one?
Yeah, that's the one in London
That's the
form,
one.
yeah.
Okay. So
Yeah.
we'll go through this and then we'll kind of be switching to the discussion as well, okay?
Okay.
So you've got, so the unit is again tort law. It's a level 5 and it's 30 credits.
Okay.
In this assignment, you are employed in a London law firm. Your client is Mr. Hussein Smith. Over the last couple of months, things have not gone well for him, and a number of serious events have taken place, for which he needs legal advice. He has sent you a letter explaining the range of problems, and you need to prepare for a forthcoming meeting with Mr. Smith. In preparation for the meeting, make detailed structured notes using relevant cases and statutory provisions where needed. So here you need to look at case law, you need to look at the law as well, okay? So any sort of laws in regard to it. So Hussein's letter, this is his letter. Dear Sir, Madam, I own and run a laundrette in South London. Until recently, I had 3 employees, Amber, Gordon, and Delphine, who were new to the job and employed for only 5 weeks. Being relatively inexperienced, Delphine overloaded one of the dry cleaning machines with garments, and instead of filling it with a solution for dry cleaning fabrics, she filled it with solution we use for maintaining and cleaning the machine. This caused a fire in the laundrette. I immediately called the local fire brigade and managed to get Ella, a customer in the laundrette at the time, Delphine and Gordon out of the laundrette. Gordon was uninjured, but Delphine suffered 2nd-degree burns. Ella had minor burns on her feet. Amber was still inside the laundrette, and in order to rescue her, I went back inside through the flames, and Gordon saw me taking this action and had a severe psychological shock and collapsed at the scene. Michaela, another customer, was on her way to the laundrette, and having also witnessed me going into the laundrette to rescue Amber, suffered a nervous shock. The fire brigade attended the scene 20 minutes later, 20 minutes after I made the phone call, but did not have the correct length of water hose and was unable to extinguish the fire. However, they managed to rescue Amber and I from the laundrette. The fire caused significant damage. It destroyed all the garments in the laundrette belonging to different customers. All the equipment and the interior of the premises were blackened with smoke damage. Delphine was taken to the local hospital for emergency treatment. The doctor that attended to her was recently qualified and, due to inexperience, administered the wrong treatment. This caused Delphine's condition to deteriorate and she suffered cardiac arrest and died. Delphine's husband, Fred, was devastated by her death. On leaving the hospital, he saw me and in anger punched me in the face, breaking my nose. In addition to these problems, I then received a letter signed by the owners of other businesses in the same street as the laundrette. They stated that the state of the laundrette is a disturbing sight that it affected their trade, and unless I took immediate steps to repair it and compensate them for their loss, they were going to bring an action against me. One of the neighbouring shops, the printing office of a local newspaper, published an article in yesterday's edition of the paper blaming me for the accident. The headline of the article read, "This is what happens when incompetent people operate a business." The article was accompanied by a photograph of the fire-damaged laundrette and me. I'm devastated and need your advice. So the first bit of it. So we go back to, can you see when I go back? Can you see this? Yes.
Yeah.
Okay, so I'm going to go back to the, can you see this, the PowerPoint slides?
Yes, task.
Okay,
Yeah.
so task 1, in preparation for the meeting with Mr. Smith using relevant case law and statutory provisions, you need to produce a file notes. In the file notes, okay, so let's, I'll be switching back and forth, okay? So, it's the same, okay. In the file notes, you need to analyse the aim of tortious liability, okay? So when we look at tortious liability, we're looking at the fact that what is tort law? What is it? What do you think when we talk about what tort law is? What do you think it is? So in 1.1, this is asking you to analyse the aims of tortious liability. What do you think we need to do in here? Do we need to look at what tort law is?
Tortious liability to figure out who's liable for the.
But do we need to, because this is the start of the assignment, so this is the first task, task 1. So would we need to identify what tort law is?
So we just has to explain what is torts law.
You need to look at the nature and development of tort law. Okay. So we need to look at the issue that tort law is concerned with civil wrongs. Okay, and it is the primary aim of tort law. What is the primary aim of tort law? What are we there to provide?
Assistance to the victim.
But what kind of assistance? Is it like a monetary relief? Money.
Compensation, yeah, I guess. Yeah.
So the primary aim of tort law are to provide monetary relief to injured parties for civil harms caused by others who are at fault, to impose any sort of liability on the responsible parties, and to deter future harmful acts. So here we are trying to provide monetary relief, but say that obviously if we are liable for the act as well. And when we look at tort liability, it can be imposed. So we look at tortious liability, it can be imposed in many instances that include negligent behaviour towards a person or land, negatively affecting a person's reputation or limiting freedom of movement. So this is what tortious liability means. So we need to look at here the nature and development of tort law. We need to look at the absence, the purpose and imposition of tortious law. So what tortious liability. We also need to look at the distinction between tort law and criminal law here as well. Why do you think that's important?
It's not to confuse between because the tort's not actually punishing the crime, isn't it?
Yes, excellent. So what's the difference between, for crime law, do you need to commit a crime?
Yes.
Yes, and for tortious liability, it's not a criminal offence as such, is it? It could be a criminal offence, but starting off, you know, it's to do with trying to get monetary relief, isn't it?
Yeah.
Okay, so you look at things like, also you may need to look at intentional and unintentional torts, which we're going to go through a little bit later, okay? So I'll go through it with you. So you need to analyse the aims of tortious liability. So that's AC 1.1. That's all within task 1, okay?
Okay.
Then you need to look at analysing the main examples of torts. their essential components, defenses and remedies. And that's quite a large area, AC 1.12. So here we would look at the remedies for the claimant. So what kind of remedies are available?
Money.
Money, okay. Damages, yeah.
Yeah, money, and like you said, preventing in the future to do that thing.
Yeah. So I'm going to go through a little bit of some remedies with you, so you've got a little bit of an idea. So remedies for the claimant. These are remedies for the claimant, okay? So they could get an injunction, okay? An injunction is a prohibitory injunction which would prevent the defendant from doing something, and a mandatory injunction which would make the defendant do something. They are serious, and if you don't obey them, you will go to court. So injunctions are an order that is put through a court, and if you do not obey them and you breach them, you will go back to court.
Okay.
Then the next remedy for the claimant is damages. Okay? So damages are the next one. And the first one is general damages. So if the claimant is subjected to pain, suffering, or loss of amenity, he or she will be able to receive general damages. Usually general damages is only nominal. So do you think general damages is a big amount or a small amount? It's normally a small amount is general damages.
Okay, why?
Because it doesn't, it's just subjected on the pain. So, you know, the person that saw him go inside when they suffered psychological loss, they might fall within general damages.
I see. So the person died?
Well, we're going to go through that one in regards to this. So special damages. Okay, this is another one.
Oh, I see.
Yeah. So there's different kind of damages dependent on what's happened. Okay. So special damages, and this is itemized out-of-pocket expenses. For example, if the defendant injures you and you need to go to the doctor by taxi, you can get your money back from the defendant through special damages. Special damages can add up to quite a lot of money. For example, if you have to go to the appointment 3-4 times a week, it all adds up, doesn't it? So special damages is out-of-pocket damages. Okay. So then aggravated damages, the next one. This is damages for injury to feelings. Do you think that person that's looked at everything and then fainted, do you think they would fall within that? Within the aggravated damages. Yes. This is damages to the feelings. For example, humiliation and things. Yeah. And then we've got exemplary damages. Now, this is damages against public authorities where the police have acted unlawfully. Such damages are rare, but are available. So these are damages for the claimant. Okay? These are not damages for exemplary. Exemplary. So that's things like, you know, damages is mainly against public authorities. Okay? So these are remedies for the claimant. Okay? And then we've got now defenses for the defendant. So these are defenses. Okay, so you have to look at defenses and remedies as well. Okay. So the first defense is consent. This is defense for the defendant. So consent is the first one, and this must be given freely by the claimant without duress, fraud, or misrepresentation. Then you've got contributory negligence. So here the claimant contributed to the situation they find themselves in. And then we've got necessity, the next defense. The defendant acted in order to prevent greater harm, so to provide treatment to someone who cannot consent. Then the next defense is self-defense. So the defendant here had to use force to protect a person or property. And then we've got lawful arrest. So any person can detain someone who breaches the peace. Okay. So here a wrongful act against an individual or his property is a tort. It involves the violation of their civil rights. A wrongful act that affects an individual and the entire society is a crime. So that's the difference between a tort and a crime. Do you understand? Yeah. So a crime is something that affects an individual and the entire society, where a tort involves, who does it involve?
Between the, let's say,
Individual.
individual.
Individual or his property.
Yeah.
Okay. Crimes are forbidden to protect society and maintain peace. A tort is a civil wrong by the tortfeasor that unfairly results in loss or harm to another. This makes the tortfeasor liable to the other. Tort is distinguishable from two kinds of laws, criminal law and contract law, and is dealt with civil courts. Unlike tort, the criminal law are wrongs against society and is comprised in legislation and prosecuted by the authorities and dealt with in criminal courts. In contract law, the rights and obligations between the contractual parties are governed by the contract itself, not by the law of tort. So you look at that in regards to 1.2. There is, I'm going to go back to the other one and I'll show you why. If you look at this assignment thing, it actually suggested, have you got this assignment thing with the guidelines for the assessor?
Yes. No, I don't have this one.
You don't have this one. Do you have this one?
Level 5. Yeah, I have this one. Yeah.
So if you look at the back of this, can you see that?
All right. Yeah, it's on the bottom of it, right?
Yes, it's really,
Okay.
really helpful. And that's what I've been going through to make your notes to help you. So this identifies each learning outcome. Can you see it?
Yeah.
So we're going to go through this, but it's good that you've got this. So I'm going to go through that with you, okay? So I'm going to give you notes on that in regards to what I know, what I could give you in regards to completing the tasks, okay? So now so we've looked at the main examples of torts, their essential components, defenses and remedies. Here you can look at distinction between intentional and unintentional torts, such as things like, assault, battery, false imprisonment, protection of harassment act, and the overlap with criminal law. And then the next one is appraise the rules for prevention of harassment and intentional harms, AC 1.3. Can you see that? Yeah. So here we look at unintentional and intentional harms. So first one is intentional torts. What's intentional torts? What does it mean when we talk about intentional torts?
Doing it deliberately.
Yes, excellent. So intentional, you have the intention. So intentional torts means when an individual or entity intentionally behaves in a way that causes another person harm, it is categorized as intentional tort. Okay? Intentional torts can come with both criminal and civil ramifications for the at-fault party, or of which vary from state to state, but may include mandated court orders, fines, restitution, probation, jail, travel restrictions, bans, money damages, and more. Common examples of intentional torts include, what could be a common example of intentional tort?
To hit somebody.
Excellent, excellent. To go out and assault someone, yeah?
Yeah.
That's intentional, isn't it? Because you have the intention to do it. Okay? Yeah. So common examples of intentional torts include assault, battery, defamation of character. What does that mean, defamation of character?
To deliberately reduce somebody's reputation by false claim. Yeah.
Do you think that happens a lot as well?
Yeah, and the politics, look at the politics,
Yes, politics. Let's not go into politics. Everything happens a lot in politics, So to defame someone. So common examples we said were torts include assault, battery, defamation of character, fraud, invasion of privacy, false imprisonment, coercion, which is taking someone else's property and converting it into their own.
What's that called?
Coercion.
Coercion.
So taking someone else's property and converting it to their own. trespass,
Yeah.
trespass to land, so using someone else's personal property without consent,
Yeah.
and deliberate infliction of emotional distress and more. So there's more unintentional torts. Then we've got unintentional torts. What do you think that means?
Happening accidentally.
So there's no
Without,
intention, okay?
yeah,
There's no
yeah, no
intention of
intention.
doing it.
Yeah.
So when an individual or entity unintentionally or inadvertently behaves in a way that causes another person harm, it is categorized as unintentional tort. Unintentional torts are based around negligence, which even though can be accidental, can still be punishable under civil law. So they're still punishable, okay? Even though sometimes it may be accidental. So ramifications usually involve recompense or restitution. Common examples of unintentional torts include car accidents, which is a common one, slip and falls, medical malpractice, dog bites, and workplace accidents. Now, these are common examples. You know, there can be more, but the fact is these are, the ones that come up quite a lot. So when we look at an intentional and unintentional tort, so an intentional tort, again, when we look at it, is, like you said, is done deliberately, while an unintentional tort is done through human negligence. In other words, intentional torts have malice, while unintentional torts are accidents. Malice meaning the fact that they have the intention to do this, and it's a planned thing, okay? Whereas, unintentional torts are accidents. So, the fact that you may have a car accident or anything like that, accident at a workplace, so it does happen. As we mentioned, some examples of intentional torts, there are many different examples. Assault, where you maybe can involve a threat or any sort of physical contact. Battery occurs where you hit someone or you touch someone in an offensive way. Conversion, depriving someone of their own property. So that could be theft, couldn't it? And defamation, things like false statements presented about someone, false imprisonment, so detaining someone, falsely. And there are so many examples of intentional, more than unintentional. Then you can look in regards to this one at the Protection from Harassment Act 1997. And this act, the main main aim of this act was to protect the victims of harassment, and it was there to protect such victims in regards to stalking behavior. It was introduced, the whole point of this act in 1997 was introduced to deal with the problem of stalking. Do you know what stalking is?
Following somebody.
Yes.
Yeah.
It involves a lot of stuff to stalking. It's quite and it could stalking become a criminal offense as well?
I mean, it's very hard to prove, right?
Yeah. Only if you've got for example, if you've got like videos or pictures of the person following you or doing something, then it's not hard to prove, for Sean. You need to be able to, when you go to court, you need to be able to have evidence there on any case, mustn't you, to prove it? You can't just sentence someone without evidence. So, if it's a stalking thing, and there was an increase in stalking at that time, so the legislation was introduced to deal with the problem of stalking. However, it doesn't just cover things like stalking. It has a much wider range of behaviors, such as, including behavior which alarms or distresses the victim. And the act gives both criminal and civil remedies. So it could become a criminal offense as well. The fact that you're a serious offense where you're a victim of harassing someone, continuously, it could become a serious offense. So you really have to be careful when it comes to issues of stalking and things like that. So that would be looking at the task 1. So we'd look at the defences, the consent, self-defence, negligence, distinction between intentional and unintentional torts, and the overlap with criminal law, but also look at the protection of Harassment Act 1997. So that literally covers the issues regarding learning outcome 1 in regards to the first task. Yes?
Yeah.
Is that okay? Are you okay with that one?
Yeah.
Okay. So this was the first task here. So let's just go back to that. For that, there was no merit or there was no extension activities for that. Okay.
Okay.
So that's task 1. Task 2 now. Let's look at task 2. From Mr. Smith's letter, you are clear that he showed a duty of care to his staff and customers. Assess when a duty of care will be imposed. AC 2.1. What is, when we look at this, what is a duty of care?
Duty of care is that the statute written of a particular job. Hello? Hello? Hello?
What did you say? What was that?
No, duty of care, for example, a person working in a government office.
Yeah.
So they have written guidance by the statute of statutory duty.
Yeah, you have a duty not to harm anyone. Okay, you have a duty of care.
Yeah, but that has to be mentioned in their job role or the constitution.
Yeah, it has to be when it literally is in their constitution. It's not mainly in their job role. But they should know from the job they're doing that they have to have a duty of care. And it's just for staff and customers. So as an employer, you must have a duty of care to your staff and your customers. Okay, so the first one was assess when a duty of care will be imposed, and that's AC 2.1. So a duty of care, I'm just going to tell you what it is. Duty of care constitutes the first of 3 primary elements of tort: duty of care, breach, and causation. Whilst there are many situations in which an individual might have acted carelessly, unless they have a duty of care to the person harmed by their carelessness, and then no claim will arise. The key is a point, whilst a case might present the clearest existence of a breach and causation, it will fail if the duty's care is not present at the time of the breach. So do you think in that situation where Mr. Smith had a duty of care to his staff?
Yes.
Did Mr. Smith have a duty of care to his staff?
Yeah, because he's employee,
Sorry,
right?
I can't hear you, Farshan.
Sorry?
I couldn't hear. What did he say? Sorry.
I mean, they are the employee, right?
Yeah.
His employee, so he have a duty of care.
Yeah, he should have a duty of care, shouldn't he?
Yes.
Because he's his employee, so all employees should have a duty of care for their staff.
Yes.
So then, although the term duty of care can seem a little alien at first, it can roughly be thought of responsibility of an individual to not harm others through carelessness. For example, a driver on the road has a responsibility to other road users to not cause an accident through driving carelessly. In other words, they have a duty of care to other road users. Do you understand that? So if you're driving a car, Farshan, and you don't put your seatbelt on and you cause an accident or something like that, because of the fault of your own, you have a duty of care. So you should have put your seatbelt on and you should have been careful, to the next person, because you have that duty of care when you're on the road.
Okay.
Because of its ability to make or break a given case, duty of care is often thought of as a control mechanism within the law, essentially a way for the courts to make a distinction between cases which are legally significant and therefore worth pursuing are those cases which do not merit the legal attention. The development of duty of care was identified in the important case, you know, the case of Donahue and Stevenson, 1932. It was the
Uh,
case, it's the case to do with the snail in a bottle.
yeah.
Yes,
Okay, I
it was
remember
quite a
that.
popular case, actually. That's where
Yeah.
the legal basis for finding a duty of care was established, and its main roots was from the case of Donahue and Stevenson.
Okay.
And this case provided the theoretical basis for the duty of care, and thus more modern negligence. So it's necessary to familiarize yourself with this case. So before Donahue and Stevenson case, the concept of duty of care did not exist in any particularly notably form within English law. This meant that
Okay.
unless a plaintiff had a contract with a defendant, they had no means of bringing a case in negligence. This led to considerable number of injustices when individuals were injured by clear instances of negligence. So
Mm-hmm.
because they had to bring this principle in, because people were not being treated fairly, there were loads of cases of negligence.
Yeah.
So this concept was applicable in the case of Donahue and Stevenson, and it was created to try to protect individuals, because you know everybody was going through lots of cases of negligence, but there was no kind of definition or anything on duty of care, and this concept was identified in the Donahue and Stevenson case. So you would have to look at that case as well. The other case that you may have to look at in regards to this is the Caparo one. And this identified the prong test from Caparo, and this looked at the duty of care. The Caparo case, the test was established for a duty of care. And thus it is important that you have an in-depth knowledge of how the test is applied. The Caparo test is made up of 3 stages: forcibility, proximity, and fairness. The first stage revolves around whether it's foreseeable that the defendant's carelessness could cause damage to the claimant. What do you think that means?
To able to predict it will happen before it
Yes.
happens.
Yes. And then what's proximity?
Proximity, it's kind of a neighbor principle.
Yeah.
Is that uh, is that the person who close to that act, uh, so the person who committing it can see it will harm them.
Yeah. And what about fairness? What do you think that is?
Fairness. I mean, it is justifiable to hold liable for the person who committed. Is it
Yeah.
fair?
Yeah. So you need to
Yeah.
be fair, don't you? You
Yeah.
can't just, act in the fact that, there hasn't been any sort of the carelessness. Okay. And some other cases that you can look at in regards to this is the case of Hinz and Berry,
Mm-hmm.
Hinz and Berry 1970, which was quite an important case in regards to looking at the issue of duty of care here.
Yeah.
And also another case, which is Berans and Oz. And that identified the issue of, negligence again, how you'd look at the fact that, how you'd assess the issue of negligence. So assess the consequences of third-party interventions as well. And that would be through case law and third-party interventions, looking at the Caparo case. And then when we illustrate circumstances when psychiatric harm can be compensated, what do you think that means? Psychiatric harm can be compensated. Why do you think psychiatric harm would affect someone? So in this case, you know, when we looked at the psychiatric harm, what was the issue in regards to that in this case, in Mr. Smith's case? Hello, Farshan?
Sorry, the person who fainted?
Yes, yes. And there was the other person as well, wasn't there?
Yeah.
Yeah, there were
So,
two people.
mhm.
So
So
why do
the
you think psychiatric injury is important?
you may you may not going to be injured physically, but in the long run, the
Yes.
mentally affected
Yeah.
diseases will harm the mental health of the person, or
So it could be
maybe
nervous
even
shock, couldn't it?
nervous
It could
shock.
be
Yeah,
nervous
yeah.
shock, yeah. So in regards to that one, 2.3, all claims for nervous shock have to be founded upon a recognized psychiatric injury that has been medically diagnosed. The
What will
psychiatric
happen? What will happen? A person not just get a not get injured physically, but he just not being diagnosed mentally as well. But in the long, like let's say 2-3 years or 1 year, and he will fall ill, and later he recognizes because of that accident I've been
there
witnessed.
must be something, you know, to build up to that. You know, you could say
Okay.
3-4 years on, but you know, there must be a build up from the start, because you can't just say 3 years on, this has affected me.
No, at least let's say 6 months.
Yeah,
But
yeah.
the person can argue it happened 6 months before. So how to justify? Because for example, the proximity will apply on that one, isn't it?
Yeah,
It's
the
like a,
proximity will apply, but you know, if you're able to identify that it's caused you this unreasonable, you know, nervous shock, or it's caused you this mental health issues or psychiatric issues, then you know you're able to identify that, and that would be with doctors' reports and things like that.
okay.
It says here also the psychiatric injury must also be reasonably foreseeable. What do you think that means?
A psychiatrist injury to be foreseeable.
Yeah.
Uh, it's very hard to foresee, isn't it? That's what I'm trying to say.
Well,
Mm,
it's not in some instances, which I'm going to go through now. The
mm,
psychiatric injury must also be reasonably foreseeable. Unless the defendant knows the victim, they can assume
mm-hmm,
that the victim is no more sensitive than the ordinary person. Where the victim was in danger of physical injury, it is enough that physical injury was reasonably foreseeable. Okay,
yes,
so
yeah.
that shows. As to who can claim, we distinguish between various groups, but these are some important ones. Those in the area of reasonably foreseeable physical harm, those
Mm-hmm,
who reasonably fear themselves to be in danger,
mm-hmm,
those who have a close tie of affection with the victim of an accident and are near to the accident in time and space. That is an
mm-hmm,
important one. Those who suffer reasonable foreseeable psychiatric illnesses due to stress at work.
mm-hmm,
And those who suffer reasonable foreseeable psychiatric illness due to the defendant causing damage to their property.
mm-hmm.
The next one is quite an interesting one, rescuers. It is a mixed bag of particular situations, and it must be remembered that negligence law can expand to fill more situations if necessary. So rescuers can be affected as well.
Mm.
The law adopts a restrictive approach in awarding damages for negligently inflicted psychiatric injury. In addition to the Caparo test for imposing a duty of care, the courts have laid down several obstacles which must be satisfied by claimants in order to establish a liability for negligently inflicted psychiatric injury. Firstly, there must be an actual psychiatric injury, and that was the case we looked at in regards to Hinds
Mm.
and Berry 1970. So I'll read a little bit on the case in this regard, okay? So
Okay.
Mr. and Mrs. Hinds went for a day out with their family in Bedford Dormobile. They had 4 children of their own and fostered 4 other children. Mrs. Hinds was also pregnant with her 5th child. They stopped in a lay-by to have a picnic. Mrs. Hinds went across the road with one of the children to pick bluebells, you know, little flowers. Mr.
Okay.
Hinds was in the dormer boil making tea with the other children. Okay. A Jaguar car driven by Mr. Berry then came hurtling at the speed. A tire burst and the driver lost control and smashed into the dormobile. Mrs. Hinds witnessed the horrible scene. Her husband died and the children were badly injured. As a consequence of this, she became morbidly depressed. Okay. So she became depressed because she saw everything. It was held in court that she was entitled to recover as she had demonstrated a recognized psychiatric condition as opposed to her feelings of grief and sorrow. Lord Denning at that time said, in English law, no damages are awarded for grief or sorrow caused by a person's death. No damages are given for the worry about the children or for the financial strain or stress or difficulties of adjusting to a new life. Damages are, however, recoverable for nervous shock or, to put in its medical terms, for any recognizable psychiatric illness caused by the breach of duty of the defendant. So do you understand that because she was a bystander, you know, she suffered psychiatric injury?
Yeah.
You know, it wasn't the fact that she's lost her husband, she suffered it because of the damage.
That
Okay.
witnessing that
Yes,
that
witnessing
scene,
is a
right?
big
Okay.
thing, you know. Sometimes for Asham, people think it's not a big thing, but witnessing something is a very big thing sometimes. Okay, so for the merit one here, you must analyze the following factors. So firstly, you must analyze the factors that may render damages too remote, and that is 2M1. Okay, and here you need to look at the remoteness of damages. Okay.
Yeah.
So remoteness of damages relates to the requirement that the damage must be of a foreseeable type. What do you think that means?
Sorry.
Remoteness of damages relates to the requirement that the damage must be of a foreseeable type.
Foreseeable type. It should be able to see, okay,
Yeah,
this kind of incident
yeah.
will cause
Cause
this
this
kind
damage.
of yeah.
Yeah.
Okay.
So remoteness of damage relates to the requirement that the damage must be of foreseeable type. In negligence claims, once the claimant has established that the defendant owes them a duty of care and is in breach of that duty which has caused damage, they must also demonstrate that the damage was not too remote. Remoteness of damage must also be applied to claims under Occupiers Liability Acts and also to nuisance claims. Remoteness of damage is often viewed as an additional mechanism of controlling tortious liability. Not every loss will be recoverable in tort. Originally, a defendant was liable for all losses which were a direct consequence of the defendant's breach of duty. And this was a case in regards to this was the case of Re Polismith and Furnace, 1921.
This is what I just made me reminded. One of my friend in London. He worked in a petrol station.
Yes.
A guy came and took the fuel pump and set the fire.
Yeah.
And he's on that box, you know, the petrol station have a shed, yeah. So the pump outside, he's in the middle of the glass box. So he's seen that happen. Then he's caught fire, and he ran away. And then he ran into places, and he got fainted because of the smoky oxygen.
Yeah.
Then now, after a few years, he been mentally, like you said, but it's a
it's been
remote, but
scarred,
it's a
hasn't it?
yeah, it's a remoteness, but
Yeah.
that's why, for example, so now he went to the court, but I don't know what happened, but in this case, for example, what he can do,
I mean,
because
it
now it's
depends
like
on each. It depends on each individual case, but if he did get psychiatric injury towards what had happened, he would be able to make a case against that.
but the
And get
employer,
some.
but the employer blamed on him. The employer said, you didn't authorize the pump. If a
Yeah.
person come with a can, So therefore, you breach your misconduct, and they discharge him and they throw him out of the work, and he
Yeah,
got
but
injured. Everything.
he could go to court, to an employment tribunal, in regards to what's happened, why they dismissed him without evidence, because you know you can't just dismiss anyone.
Yeah, but now he
So
lost both job and his health, so
yeah,
he didn't get
so
any
he
compensation
needs
from.
to he would
Yeah.
need to go to an employment tribunal
But it
and
would
do
be
a
too
case.
late because it's now like 4 or 5 years.
He can try. He can contact someone called ACAS, and
Okay.
they deal with all the employer situation. And I think there may be a cut-off point for how long it is, but I don't know the period.
Mm-hmm.
So you know,
They may
maybe he
they may
can
be
try.
overlooked because of his mental health, because of even if they say like say you have to bring the case between 2 or 3 years, but
Yeah,
because of he mentally suffer, they will
yeah.
overlook that one because
Maybe,
of
yeah,
it.
they may, but if you know, he needs to first contact ACAS to see that he was, wrongfully dismissed, and then
Okay.
he should have taken an action against his employers.
Yeah, I think because they dismiss it because they thought he gonna go to claim compensation against the
Yeah,
company or something
yeah,
like that.
yeah.
So this is very
Yeah,
unfair. Yeah.
it is very unfair. It is totally, these cases that are so unfair. When we go on to the employment side of it, you will feel like, people have been dismissed for stupid reasons, to be honest.
Yeah.
Okay, and then for the distinction grade, you need to look at assessing the application of public policy in limiting the scope of duty of care. And here we look at the public policy. We can look at things like duty of care from the ambulance service. We can look at duty of care from the police, fire brigades,
Yeah. Yeah.
educational and care bodies. What do they have a duty of care, and their limitations, and how they interpret this duty of care. So that would be looking at the 2D1 in regards to public policy in limiting the scope of duty of care, and looking at the interpretation and application, but also looking at public bodies like the police. They have a duty of care, don't they? The police have a duty of care to the individual, to the public.
Yeah.
Do they breach their duty of care sometimes?
They do.
Yes, they do. Yes. The doctors, ambulance service sometimes breach their duty of care.
Mm-hmm.
So that's the distinction part of it. For the distinction grade, that's what you need to be looking at. Okay,
Okay.
so you need to be
Okay.
looking at the different organizations, the duty of care from the police, the duty of care from ambulance service, fire brigades, any sort of educational and care bodies, what their limitations are, things like that. So you need to be looking at that in regards to this.
Mm-hmm.
Okay, so before
So
we carry on,
just to finish
yes,
the
yeah,
point, I don't know, I disturbed you. Okay, okay,
yeah,
you can say.
yeah. No, it's okay.
Can I? Okay.
Shall you can,
So we just mentioned it should be foreseeable, it should be a duty of care, it should be
yeah.
too remote. So too remote mean, is it mentioning the time period, or is mentioning the proximity? What is the meaning of
No, the
too
true
remote?
remoteness, we've looked at that in regards to what remoteness of damages include is it's an additional mechanism. So not every loss will be recoverable. What they're saying that it's remote.
Meaning how many years before the case
It
broke in,
doesn't
or?
it doesn't actually say that.
Okay. Okay.
But I know that remoteness of damage relates to the requirement that the damages must be of a foreseeable type.
I
That
see. I see.
the claimant has established that the defendant owes them a duty of care. So the claimant could be you as an employer, and your friend could be the employer, and then the employee could be obviously needs to provide him a duty of care, and that duty of care has been breached. So they need to
Mm-hmm.
look at it from that perspective.
Okay.
And the distinction bit, again, going back to public implications, special cases regarding the extent of the duty on police, ambulance services. Do you think their duty of care extends a little bit?
Duty of care
For like
extends.
ambulances and police, do you think they should have an extra, do you think their duty of care should be, the extent to their duty of care should be more than a duty of care normally?
toward another individual.
Yeah, to an individual or to the general public, because that's what they owe a duty of care to.
Okay. It depends on the circumstances, right?
Yeah,
Sometimes
yeah,
they breach the duty of care for the greater good,
yeah,
like you mentioned in there.
yeah,
For example, to stop a guy run away with another person car. So
yeah.
sometimes the police hit the person car to prevent the big accident in the motorway or something because he going the wrong way or something like that.
Yes, yeah. And do you think that happens a lot?
Yeah,
Yeah,
yeah.
it
I
has. Yeah,
noticed. Yeah. I noticed a guy drive away a stolen car, but police chasing him.
yeah,
So he went to the opposite direction, so the police can't chase him because he going the wrong way.
yeah.
Then they sent another group of police to stop him by hitting him,
Ah, yeah,
because
yeah,
otherwise he gonna cause a big accident and
yeah,
close the motorway and things like that. Yeah.
yeah. So the next thing that the other thing that you may need to look at in regards to the distinction bit is the principle of the floodgate principle, and that principle is in tort law is floodgate. The floodgate principle or the floodgate argument is a legal principle which sometimes is applied by judges to restrict or limit the right to make claims for damages because of a concern that permitting a claimant to recover in such situations might open the metaphorical floodgates to a large number of claims. Do you understand? So
Yeah, yeah,
if
yeah.
someone makes a claim, this is something that the judges have, but if someone makes a claim for walking down the street and doing something that's stupid, then it opens the gates for everyone to do it, doesn't it?
Hmm.
So this is where the judges can restrict the limit to make claims for damages.
Okay, okay.
So it's just for the minor stuff here that they don't. So you need to look at the principle of the floodgate prevention. And what we'll do now is I'll give you a break because we're going to carry on, but stay online. Don't
Okay,
go off. Okay, stay online
okay.
because we're on for another hour. But I'll give you a 10-minute break so then we can carry on with the third one and the fourth one. Then, okay.
So
Have you
one
got any
oh
questions about the first and second tasks?
no, so I'll come back 1 o'clock and 5 minutes, yeah?
1:05. Just stay
Five
on.
past one, yeah,
Stay.
yeah.
Don't go off though, Farshan. Okay.
Okay, okay. I'm not
Okay.
going off.
I'll
Yeah.
be on anyway. Okay.
Okay, okay.
Okay. Okay.
See you.
Okay. So we're gonna start the next bit of the task, which is task 3 now. Okay.
Yeah,
And
okay.
this looked at Mrs. Smith is also concerned about his liability. In the file notes, you need to distinguish between primary and vicarious liability, and that's AC 3.1. So you need to
Okay.
identify what vicarious liability is and what primary and vicarious liability, primary and vicarious liability is.
Is it, how do you pronounce it? I thought it's a vicarious,
Vicarious liability, yeah.
Oh, okay, that's how I pronounce it. Okay.
So vicarious liability in English law is a doctrine of English tort law that imposes strict liability on employers for the wrongdoings of their employees. Generally, an employer will be held liable for tort committed while an employee is conducting their duty. So in this case, Mr. Smith, do you think he's obviously liable
Um,
for his staff members?
yeah, because it's caused by the inexperienced employee,
Yeah,
right?
yeah,
So therefore, it's not something his something catch fire or something from
yeah,
his side. So,
yeah,
but at the same time, um, he has to have somebody to monitor the inexperienced staff. I'm not sure. So that person not
yeah.
available or
Yeah.
something like,
So,
yeah.
but he has a statutory duty to his employees. Every employer has a statutory duty. You know,
Yeah,
and
but
here,
that is written in the Constitution, right?
yes,
That's
but
what
it's
it is.
written in the
Okay,
law as well. It's written
in
in
the
the
law as
law.
well. Okay,
Yeah, the
okay,
Occupiers Liability Act as well, and things like that. So here you will look at what occupiers liability is. Occupiers
okay,
liability is an area of law which outlines the duty of a care a person who occupies a premises owes to those who visit it, providing they are lawful visitors. Okay,
okay,
this means that an occupier has to take reasonable care to ensure visitors are kept reasonably safe when using the premises for reasons they should be there for. For example, if you go to a shopping mall, okay,
mm-hmm.
you're gonna be expecting a duty of care from the shopping center, who owns the shopping center, that they have a duty of care to you because you've come
Okay,
shopping.
okay,
The occupier has to ensure that visitors are safe from any
mm-hmm.
dangers which result of any actions which are permitted on the premises. If an
Okay,
occupier is aware of a danger, they must let the visitor know about it. For example, if there's some building work getting done in the shopping center on a shop, the occupier should be able to tell the visitors, don't go near this building because, or have signs up and things like that to
mm-hmm.
make it safe. Because if the occupier carries out their legal obligation of the care, you or anyone else visiting their premises is unlikely to suffer a damage or any sort of injury. So you need to be able, as an occupier, to identify that you have put everything in place to keep it safe.
Okay,
An occupier of a premises generally owes the same common duty of care to all people who visit their premises. However, dependent on the specific circumstances, an occupier may owe some people extra care for those who need it, such as children, extra care for skilled visitors who should have awareness of danger, slightly different care. Here you will also look at employer's liability as well, and this may fall more within Mr. Smith's situation. Employer's liability and occupier's liability are different. Employer's liability is when you have an accident at work and your employee is liable. There is
mm-hmm.
no occupier's liability in instance, but employer's liability instead. However,
Okay,
occupier's liability and employer's liability are very similar in that an employer has the duty of care to their workers, like an occupier does to their visitors. An employer
okay,
has to ensure that their work is safe, which include providing safe processes, ensuring tools are safe and up to date,
mm-hmm.
any sort of tools or anything,
Mm-hmm.
ensuring all workers know what they're doing. And that falls
Mm-hmm.
within AC 3.2, the next point. Okay.
Okay, okay,
And 3.3 as well, when we're looking at visitors and non-visitors.
mm-hmm.
Employees' duties occupier liability in general imposes a duty of care on the part of anyone who occupies the land or premises to anyone who comes onto the land. Workplaces are described as shared when more than one employee occupies premises or when contractors are used on a sole occupation. The employer has a common law duty to take reasonable precautions for the safety of legitimate visitors, and that's under the Occupiers Liability Act 1957, and of unlawful visitors such as trespassers. That's Occupational Liability Act 1984. So there's two types of visitors, lawful and unlawful.
Okay.
So lawful is visitors and non-visitors are people that are trespassing. Why is it important for employers to have health and safety in the workplace in good position as well?
Because of the visitor, isn't it?
Yeah.
As well. Yeah.
The risk, both for employers and for the visitors,
Yeah. Yeah.
under the Health and Safety Act at work, employers have a general duty to take reasonable care of their own health and safety and that of any other people who may be affected. Now, in this case, do you think that Mr. Smith breached his general duty? Do you think it was a good thing that he ran in to save Amber?
No.
No, because he breached his duty of care there. He did
Yeah.
the place, and it was just not just for him, but the fact that he put others in danger. The basis of British health and safety law is Health and Safety Act at Work 1974. The Act sets out general duties which employers have towards employees, members of the public, and those that employees have to themselves and to each others. These duties are qualified in the Act by principle of so far as reasonable practicable. An employer does not have to take measures to avoid or reduce the risk if they are technically impossible, or if the time, trouble, or cost of the measure would be grossly disproportionate to the risk. Employers therefore should look at what the risks are and take reasonable measures to tackle them. And in Mr. Smith's situation, you know, he went in straight away. He should have really looked at that properly. Health and Safety at Work Act 1974 also places a duty on employers to ensure the health and safety of the workers and employers. And a further statutory duty towards visitors arises under the Occupiers Liability Act 1957. An occupier of premises and equipment like staging and diving has a duty of care to any visitors using the premises for the purposes of which they are permitted or invited to be there. In addition, the civil law allows injured people to make a claim for damages where they can prove that they were owed a duty of care and that there was a breach of that duty that led to the injury. This is known as common law duty of care. This arises sometimes where there is sufficient proximity between the operator and the person injured. You know, things like, you know, if you go into a shopping mall, and I will use that example again, you know, the fact that if you go into a shopping mall and, you know, there's there's maybe, you know, things like, you know, scaffolding up and, you know, in a shop, and you're told you haven't been advised, you know, that this is safe for you to go, you could identify that and say that, you know, that affected you, and your duty of care wasn't given by the shopping centre. Then we've got the Occupiers Liability Act 1957. The Act came into force in 1st of January 1958. Act identifies the occupiers first, and it looks at the fact that, you know, that they have a duty of care to take such cases into reasonable consideration, and it limits to the visitors. Then the 1984 Act, when we look at duties to visitors, this 1984 Act in regards to Occupiers Liability Act was is a duty of, looks at the duty of care in regards to things like, you know, trespassers. They are regarded as non-visitors, but still we still have a duty of care to trespassers as well, don't we? It's still our,
Yeah, how that happen? If somebody come unlawfully
yeah,
and get accident, then I'm responsible because they're coming through my,
yes, yeah, it's your land. You are
yeah,
responsible then, you know, and, you know, there are, like we said, the two types of visitors who are come on the premises and someone who doesn't have permission. So one has permission and then the other one doesn't. But non-visitors, you know, sets out duties where it owes it to a person who comes onto the premises and generally who's not even allowed onto the premises. So you have a right to both them, you know, people, visitors and non-visitors. Here you would look also at the defences and warning messages, causation and remoteness, and which we'll go through a little bit later, which I'll go through with you, okay? Then we've got the task 4. Task 4 is in regards to, in order to address the issues posed by the local businesses and the article in the local newspaper, you need to distinguish between private and public nuisance claims, which is AC 4.1. Public nuisance concerns protecting the public, unlike private nuisance, which protects an individual. In some instances, the same sets of facts can produce liability in both kinds of nuisance, although the two types of nuisance are very much distinct. Private nuisance is concerned with protecting the rights of an occupier in respect of unreasonable interference with the enjoyment and the use of the land. The parties to take an action in private nuisance are generally neighbours in popular sense of words, and the courts undertake a balancing exercised between the competing rights of land. So do you know firstly what is nuisance?
To be a disturbance to the neighbors, right?
Yeah. So private nuisance is the fact that, you know, is concerned with protecting the rights of the occupier. So, you know, the private enjoyment of your own land. Public nuisance is a crime, but becomes actionable in tort if the claimant suffers particular damage over and above the damage suffered by the public generally. So what could a public damage be? Sorry, a public nuisance be?
A person drank and shouting on the town center or something
So
like
it could
that.
be things like, you know, if there's
Yeah.
any sort of, again, there's a different types of nuisances. So nuisances from flooding. Why would that be a nuisance?
Of flooding.
Yeah.
What's that mean? Mean
Flooding,
water?
you know, like if water, water.
Yeah.
So if you've got like Yorkshire water and the pipe burst and there was flooding or
Yeah.
due to so that could be a nuisance from that.
Okay.
Because it's
Okay.
affected the public as a whole, generally. Also, nuisance of smells as well, you know, like sewer smells. Do you know what the sewer is?
No.
Sewer smells, you know, like toilet, gutter, things like that.
How to spell that word?
SEWER.
Uh-huh.
That could be
Okay.
a public nuisance as well.
I see.
Also, nuisance of noise, like you just mentioned.
Okay.
And also, you know, if there's any sort of another example is, you know, if there's any sort of brothel. Do you know what a brothel is?
The sex industry.
Yeah, sex industry. Yeah. So if there's a
Okay.
brothel around where you live, there's disturbance from a brothel. That could be
Okay.
a public
Okay.
nuisance as well. So there are two types of nuisances which we've identified, which is private and public, and that's what you need to distinguish in 4.1. But you need to give some examples like I have as well. Okay. 4.2, compare and contrast effective and ineffective defenses. 4.2. So the first one is the defense of prescription, which only applies to private nuisance. It claim that defendant has acquired a right to a cause relevant nuisance because they have done so for the last 20 years. This is similar in the manner to like property rights and things like that. There are three possible remedies available where defendant is to have found to have committed a nuisance. You've got injunctions, damages, and abatement. And there are defenses available to people causing a nuisance as well. So you've got effective defenses, which is a nuisance in the case of private cases. So this means that if the defendant has been performing the same activity, like we said, for 20 years. The next one is when an act is carried out following the law is a complete defense. So a railway company that authorized to run railway trains on track is not liable. Ineffective defenses, which are there are two or more than two per so these are ineffective defenses. The act of two or more than two persons are not dependent on each other, may cause nuisance, although the act of any one of them would not so. Again, you look at public good and reasonable care here. And some of the remedies we'll look at in regards to that would be generally, what would a remedy be in regards to nuisance? What do you think?
Injunction.
Could you get an injunction?
Yeah.
Yes, you could get an injunction. Okay, and that's important in regards to trying to get an injunction in regards to trying to prevent someone going onto your property. And it could
What
be
else? What else? For example,
a monetary form. It could be money as well.
Okay. Okay.
Money could be another one.
Let me
Okay.
say, let's say if people living in a flat and the next neighbor putting music and dance and things like that.
Yeah,
So,
I
so
don't
that
think you could, I think you could complain to the police and things like that and get an injunction against them. But with an
okay.
injunction, it says that that person shouldn't go near you or they're prohibited to do certain things. So the courts
Mm,
might say that if they're playing loud music, that they are prohibited to do that. You can bring an injunction against them.
mm-hmm.
Then 4.3 is looking at the Rylands and Fletcher rules and the importance of Rylands and Fletcher. And there were, I think it was 5 things that were identified in the Rylands and Fletcher case in regards to nuisance. And the first one was the accumulation of the defendant's land, a thing likely to do mischief if it escapes. Escape was the third one, non-natural use of land, and the damage must not be too remote. Again, the Rylands and Fletcher case confined to interference with the rights in land, public nuisance, which is limited to claimants who have experienced any sort of special damages. And that handout that I've given you on one of them, the case for the solicitors one, that will identify Rylands and Fletcher for you. So there's loads of,
Okay.
you can just put Rylands and Fletcher into Google and loads of things will come up in regards to nuisance. Okay. Then we go on 5.1, which is looking at defining libel and slander. So you need to identify firstly, libel and slander fall within defamation law. Do you know what defamation law is?
Yeah, to taking somebody's reputation. Yeah.
Yeah, so it's a false statement, isn't it?
Yeah. Yeah.
So defamation is a false statement presented as a fact that causes someone injury and any sort of damage to their character. For example, an example would be Tom Smith stole money from his employer. If this is untrue and if making the statement damages Tom's reputation or ability to work, it is defamation. The person whose reputation has been damaged by false imprisonment can bring a defamation lawsuit against another. You've got to be careful in this instance. That lawsuits are, defamation. It has to be something that defames your character, because defamation can be an area that's typically a little bit hard to prove, because in some cases a lot of the Hollywood actors tend to make defamation claims against magazines, like
Yeah.
Hello and
Yeah.
OK, to say that what they've produced is defamatory. Okay, so when we look at the difference between libel and slander, so there's 2 types of defamation. The first one is libel, okay, and libel and slander are 2 types of defamation. Libel is an untrue defamatory statement that is made in writing, and slander is an untrue defamatory statement that is spoken orally. So the difference between the 2 defamation is that slander is that a defamatory statement can be made in any medium. It could be a blog, comment, or unspoken, or spoken in a speech, or said on television. Libelous acts can occur when a statement is made in writing, so it could be like digital statements or made orally. So these kind of statements are quite defamatory. So that would cover 5.1. But identifying 5.1, you need to first identify what defamation law is, because you can't just go into libel and slander, because libel and slander is part of defamation law. Okay, so you need to look at what defamation law is, then the difference between both, and then the defenses as well, but also look at the Defamation Act 1996, and that will look at the defenses and damages. Okay. Assess the conditions for a claim in defamation. So suing for slander and libel or defamation brings a civil suit in a state court and alleges that under the slander laws or libel laws of that state, the person has brought the lawsuit was damaged by the conduct of the person who made the false statement. A libel or slander lawsuit seeks monetary damages from harm caused by the statement, such as pain and suffering, damage to the plaintiff's reputation, loss of wages, loss of earning, and a personal emotional reaction such as shame, humiliation and anxiety. So, you know, you could, so again, going back to the Hollywood actresses and actors, they bring a case against a big magazine such as Hello and OK. They are expecting some monetary compensation, aren't they?
Yeah.
Yeah, so there has been cases such as you know, the Kardashians. Another one is Catherine Zeta-Jones and Michael Douglas. When they got married, there were defamatory cases in regards to them of what was being published on their wedding. So they were able to sue OK Magazine in regards to that. And if you look at defending a defamation case, if the accused of defamation, slander, or libel is truth, is absolute defense to the allegation. If what you said is true, there's no case. If the case is brought by a public figure and you can prove that only negligent in weighing the statement was false, that can be a defense as well. Defamation is an area.
Defense?
Yeah,
What is
it's
the
a
defense
defense.
in this case? What is the
Yeah,
defense?
it's a
So
defense in that case.
sorry, yeah, which is that? I just lost the point.
If the case is brought by a public figure, you
Okay.
can prove that you were only negligently in weighing whether the statement was false. That can be a defense in itself if they've got enough evidence to prove that. Yeah.
I see.
Defamation is an area of law that protects people's reputations by allowing them recourse if false statements are made about them. Do you think it's a good thing to have defamation in place?
I think so because nowadays
Yeah.
it's like social media and everything.
Yes, excellent. Yeah.
Yeah.
Social media
Some people commit
impact.
suicide because of the
Yeah, they
harassment on the
have, you're
social media.
right. Yeah. People have committed suicide.
Yeah.
It does mentally affect them, you know, and it's a good thing to have for people that, you know, if something is being said about them which is untrue, then the law is there to protect them. You know, it is a really good thing to have. The other thing that introduced, which is something extra that I've put in that they've not asked, but it looks, actually they have, which is 4.3, 5.3. They looked at the remedies, but also the Defamation Act 2013, a new act which introduced a new test of serious harm for determining whether or not a statement is defamatory, intending to raise the bar for bringing defamation claims. So a statement will not be defamatory unless the claimant proves that it has caused or is likely to cause serious harm to their reputation. Under the Defamation Act 2013, the requirement to prove serious harm is a complex issue and one to be carefully considered. In brief, whether serious harm has been suffered must be determined by reference to actual facts, meaning the impact of the statement, not just the meaning of the words. The courts have acknowledged that interferences of fact can be drawn from the circumstances and context of the publication, including matters such as the extent and nature of its readership or audience and the gravity of the statement. Where a social media posting is defamatory, the damage done by this can be significant. A social media post can be shared, retweeted, liked, and thereby reach a wide audience across the world. The more readers the offending post has, the greater the likelihood of reputational damage. And like you said, you know, people have committed suicide through this. You know, so it's not something that, you know, is going to be taken lightly. So for
And it's
merit,
also human nature, isn't it? It's also
yes,
human
it's human
nature
nature
to
again.
pick on
Yes,
others. Yeah.
yeah, and some people are bullies and will do that.
Yeah. Yeah. Yeah.
For merit grade, you need to look at 4.4 M1, which is the to look at meaning and the need of fault in nuisance claims, which we looked at in regards to what that is. And for the defamation, sorry, for the distinction grade, your file notes must include an examination tension between freedom of speech and an analysis of recovery of pure economic loss. And what do you think when we come to freedom of speech and reputation? What do you think that means?
Sorry.
Well, when we look at freedom of speech and protection of reputation, what do you think that means?
is to draw the line between freedom of speech and defamation.
Ah,
I don't know. It's very hard to do it, I guess. I mean, one
why do you
person can
think it's so
argue is my,
important?
yeah. So how do you,
Because
how
people
do you
might
draw
say
that
that I
line?
have a freedom of speech, so what I'm
Yeah,
saying is not defamatory. Do you understand that?
yeah, yeah.
Because we
For
have a
example,
free because
yeah.
everyone has the freedom of speech. Yeah, you have the right to say what you want. Yeah,
Mm,
to an
mm.
extent. Okay, so but some people might say what I'm saying, um it's not slander and it's not defamation, it's my freedom of speech. But sometimes statements, they need to be argued properly, and your legal advisor needs to argue these cases properly, that it's not a freedom of speech or protection of reputation. It is the fact that, it's defamation. Because under Article 10, we all have the freedom of expression. And that
Mm.
is the fact that we have the right to hold opinions and receive, information. But when it comes to, can freedom of speech become defamatory as well?
Yes.
Yes, how would it become defamatory?
For example, maybe a little bit outside the syllabus case. For example, in France,
Yeah.
a minister burning the Quran and said,
Yes, exactly. Yeah. So,
yeah,
that could, you do have, we do say you have the freedom of speech,
yeah.
but when it comes to how it's protected, and how we look at it in regards to defamation, sometimes you can breach that, and you sometimes everyone, what'll happen is it could amount to defamation. You could say something that amounts to defamation, and defamation again is an offence within the UK.
Is it defined as an freedom of speech of act, something defined as a written constitution in
Yeah,
UK?
it's in the European Convention on Human Rights, and it's Article 10, where we have the right to freedom of speech. But
Okay.
as long as when we have the right to freedom of
So it,
speech,
it is explaining what it is, the Article 10, what is
yeah,
freedom of
Article
speech.
10 is the freedom of expression, and it's a
Okay.
fundamental right
Okay.
available. But we shouldn't abuse that right, should we really? The Article 10 says that everyone has the right to
Mm-hmm.
freedom of expression. This right
Okay.
should include the freedom to hold opinions and to
Mm-hmm.
receive, impart information and ideas without interference by public authority and regardless of the frontiers. This
I
article
see.
shall not prevent states from requiring the licensing of broadcasting or cinema enterprises. So we should take into account that public safety and
Mm,
integrity,
mm, mm.
and look at the fact that, it gives us that freedom, but reputation can be defined as other people's character, and we shouldn't be taking that into account in regards to this.
In
Um,
UK, is there any specific constitution or any clauses or anything about freedom of speech, or is only
yeah,
we
it's
relying on
European.
the?
The freedom of speech is the Article 10 in the European Convention on Human Rights, but we have signed to that. The UK has signed to
Okay,
it, so we are
okay,
signatory to that. Um,
okay.
so when we're looking at freedom of
Is that
speech and
affected
definition.
because of the Brexit? No.
No, we've signed it in
No.
1947. So it's, sorry, 1950s we signed it a long time ago. And there's
Okay.
47 countries that have signed the European Convention on Human Rights.
Mm-hmm.
And
Okay.
when we look at defamation law and freedom of speech, defamation law is literally a mechanism for protecting reputation of the individual, because we have freedom of speech and thought. So,
Mm-hmm.
we have to protect the individual's reputation. So in that instance, we have to take on board that what Article 10 does. It allows for freedom of expression, but not to defame people.
Mm-hmm.
You
Mm-hmm.
shouldn't be there to be able to defame someone's character or anything.
Mm-hmm. Okay.
Okay, so you should take that into mind when looking at Article 10. So this, let me just have a look at this in regards to that. Okay. Just give me 1 minute.
Okay.
Oh. There are so there are 5 elements of if you needed to bring an application for defamation,
Mhm.
there are certain elements you need to prove to
Okay.
bring an application. Firstly, you need to prove that the statement that was made is defamatory. So what does
Okay.
that mean? That the
It's
courts
actually
need to,
causing you harm. Yeah.
yes, so the courts need to prove that, to say that the words form an innuendo meaning. So
Okay.
they are, the words are causing you defamatory pain, like the defamatory about you. Secondly, you need to put that the statement caused or is likely to cause serious harm to the claimant.
Mm-hmm.
What do you think that is?
Either monetary or physical or
Yeah, so
emotional
it
harm.
could be the
Yeah.
fact that, if it's on social media, it'll be
Yeah.
worldwide. That could cause reputational damage to the individual. There could
Put you
be
shame and
additional,
things like that. Yeah.
yeah, it could be financial loss as well, if it's
Yeah.
a business and things like that. So it
Mm-hmm.
could cause you some financial loss. Then thirdly, was that the statement refers to the claimant. So the statement has to refer to the claimant. And in many cases, this is straightforward matter. A claimant is either directly identified by name or described in such a way that a reasonable person would deduce the statement refers to the claimant. So for example, if you did a statement about me, okay, but it had my name in, but then my husband wants to take the case to the courts, he couldn't do that because it's not affecting him. It needs to be me.
Okay.
So it needs to be, the statement must contain my name, or there must be some sort of statement that refers to me.
Okay.
Number 4, that the statement was published. So a defamatory statement must be communicated to a third party. In other words, not just to the claimant. For slander cases, so there must be some sort of oral publication. Okay, the words must be apprehended and understood by the third party. For libel claims, which is written publication, the words must be read and understood by a third party. Therefore, if a statement is published but no one reads it, hears it, there's no claim for defamation.
Mm.
The 5th one and the final one is that there is a lawful justification or other defense. Here, some defenses are available to a claim of defamation. Truth, honest opinion, privilege, which is absolute or privilege, publication of matter for public interest, innocent dissemination, and consent. So these are some of the defenses that are available, okay, that you may need to look at in regards to, if anyone was going to put in an application for defamation, they would have to prove all this. It's not something that can easily be done. You see, if you're able to prove it and then you need evidence, why do you think evidence is so important in regards to these claims?
Otherwise, it's a floodgate, right? Anybody can claim, I said
Yes.
that, you said this. Yeah.
Yeah, but also you need to be able to prove to the
Prove.
courts
Yeah.
that that you need to receive some form of compensation because of what has been happening. What the case that they've dealt with, it's not fair, and how they're dealing with it. The fact that they are not dealing with it properly, and that the fact that you've got defenses and damages available to you as an individual. So do you want me to so this is some of the references here. The other references, this is a really good book. I don't know if you've got access to it. It is on Moodle, and it is The Law of Tort. Can you, oh God, I don't even know if it's got it there, but it's quite a
No,
good book.
no such a book. The book I have: Catherine Elliott, Franz Quinn, Emily Finch, Tort-Law,
Is
Jenny
that on the
Stilson,
law one?
under the Tort-Law.
Is it on Moodle? Is it an
Yeah,
ebook
is
on
it on the
Moodle?
Moodle? Yeah.
Yeah, if it's on Moodle and it's an ebook, it's really good for you to have a. Is that the Nicholas J. McBride and Roderick Bagshaw?
Yeah, I have that book, Tort-Law, yeah.
Yeah,
Sixth
yeah,
edition, yeah.
that's really good for you to have a look at in your own time. Okay,
Okay.
and then when you've got to submit your stuff, so refer again to ebooks or Moodle, any sort of inquiries, learner.work@ukvarsity.co, submission of assignment to be done on learnerwork@ukvarsity.co, and submission is 2 weeks after the completion. Now, have you got any questions in regard to these 4 tasks that we've gone through?
The employer thing,
Yeah,
okay, let address, because I'm a little bit care about this my
this
friend.
one here.
Yeah, it's actually the case. um Yeah, I mean, I'm asking the specific case a little bit outside the modules, because this is actually happened in the BP petrol station.
Yeah.
So the guy get to fed somebody with the fire, and he got mentally, physically injured, but he been
You remember he had the duty of care to his employers.
yeah, but he put the blame on the employee and say, "Is it your fault?"
It doesn't matter. It's not
yeah.
the blame is not on the employee.
Yeah, so because he's a big company, he's an individual, they have a more defense, right? The BP, even if you go to the court and things like that,
Yeah.
because
But
yeah,
I think the individual again needs to contact some sort of employment agency.
yeah, what they did basically, they said it's your fault. They before even he go to compensation, they put they said you had to pay 16,000 or 17,000. He got the letter from a lawyer. Then he just scared and left the case alone. So
Yeah, but
they
he should
just
have contacted an employment advisor. Because I can't, to be honest, there's not something I do, but I can't advise you on that. But for it, just to tell him to contact someone that deals with things that in regards to employment law, that would give him some advice and things,
okay. So it's still
because that would help the
yeah.
person in regards to what the situation would. He'd have to tell him all his story and go through everything like that.
Yeah, even if you're not a inexperienced person, but you're saying still he have the rights to for the employment and the compensation
Yeah,
things
maybe
like
he
okay.
needs to ring, any sort of employment advisor, Citizens Advice Bureau, where he'll get free advice. But also, generally when we talk about the assignment area and stuff, a duty of care is from the employer, to the staff members and to the customers. So,
Yeah, yeah,
from
because
that
he's
perspective,
supposed to put in a duty worker with inexperienced employee. So
yeah,
the manager didn't put the duty worker, and he left him alone in the midnight to himself,
yeah.
and
So,
that's why he
these
got the
are
fire.
things that would have to be discussed.
So I think the all in all, the manager realized it's his fault, so he need to turn it around. That's what
Yeah,
he did that. Yeah, I
yeah.
think so. Yeah.
So what we need, have you got any questions around the assignment? What I'll do is I'll send you them additional notes. If you send me an email, I'll send you the additional notes, and make
So
sure you read the notes and answer the questions, but don't literally, put the notes into your assignment, make use of the notes. There's
each
quite a lot.
question, so
Yeah,
the first part is a little bit of a definition and the
yeah.
what is taught and
But then
everything. But
if
even
you go on to this first, Sean,
yeah,
this other thing that I showed you,
yeah,
let me just 1 minute. If I show you that, this is really good. Look, can you see all this indicative content?
yes,
It's very good. Have a read of that and then refer that to your tasks, because this
okay,
identifies what you kind of need as well.
okay, okay.
So,
I written down yesterday some question to ask. So what's the consequence of third party intervention? So is it on the uh where is it, the first part of the question?
which part of the question?
uh, in the task 2 second question say assess the consequence of third parties intervention. So it is who's the third party here?
Who would be the third party?
Sorry,
Who do you think would be the third party?
the Smith is the employer. The person is the employee. I don't know who's the third party here.
In this case, who do you think the third party would be?
Staff and customer.
Customer, yeah, but also the third party could be the person who saw it. You know, who walked past.
Okay, okay. So he's basically saying he can have compensation or not, right? That's the
Yes,
question.
so you know, it could be a third party intervention, could include someone who's directly or indirectly supporting a single conflict. So it could be, you know, the third party might become a direct or embedded party. So it don't have to be, you know, the fact that it could be the one that's walking past.
So it's the person to find it. That's the person that party is here. No?
Yeah, in this case, a third party is an entity that is involved in some way in an interaction that is primarily between two other entities. So a contract might be, for example, between a software company and creates a mobile app and to the end user. So third party could be the person walking past.
Okay.
Yeah, so the
Okay,
consequences to them as well, because it falls within psychiatric injury. So you'd be
Okay,
looking at the
okay.
compensation harm there as well.
Yeah. So the second question is the merit grade. You already mentioned the two remote.
Yeah,
So so the remote I can address in terms
yeah,
of the proximity and
yeah,
also the time frame.
proximity.
Is there a time
Yeah.
frame in the
You'd
law?
have to have a look at that. Which one is that? Is that the task?
Merit grade first, number one. Analyze the
Mhm.
factor that may render damage to remote to M1.
2.1
Yeah. For a merit grade,
or for the merit grade?
yeah, to M1 merit.
2M1. Okay.
Yeah, yeah. So
And that's in regards to just let me have
the
a look
factor
through that.
that may render damages to remote. Analyze the factors that may render damages to remote.
Just 1 minute. Let me just have a look through there, the notes and see which one I've done. Was that in psychiatric injury?
No, for example, the task 2 have a 2-3 question, right?
Yeah, but it was to do with
After that, after the
duty of care. It's to do with duty of care, isn't it?
okay, so the to remote here is to analyze the duty of care basically.
Yeah, so you need to look at the remoteness of damage in duty of care cases. It mainly relates to the requirement that the damage must be of a foreseeable type.
Mm-hmm.
Okay, so is the damage remote enough? Damage which is too remote is not recoverable. And even if there's clear causation, but if at the time the contract was entered, the parties reasonably have to increase the foresee the loss. So you need to look at the remoteness of the damages, but also the time's proximity.
Mm-hmm.
Okay, so try and do what you can. I'll send you the notes. Is there any other questions before we finish off?
Public policy intimidating the scope
We went
of
through that.
yeah,
Public
yeah,
policy.
we went through, yeah.
Yeah.
And prohibition of recovery for pure economic. Analyze the prohibition of recovery for pure economic loss. Where is
And that's things like, you know, what kind of economic financial loss they'll get.
no, it's a prohibition of recovery, isn't it? So that's mean they're not
Does
gonna
that?
get
Which
D2.
does that?
D2.
Which one is it?
Is it under the D2?
D2 extension.
Distinction 2. Yeah, distinction 2. Second question of the distinction.
So analysis of provision of recovery for pure economic loss. The fact that, you know, would they get any sort of loss through this? You know, would they get any form of compensation? What are the remedies
Okay.
available for them in this? You know,
What
so
is
what defenses, what damages are available, and also the fact that they'll, you know, do they get any sort of economic loss out of it? Will they get any sort of gain out of that?
okay?
Financial loss, you know, because it's important that, you know, you look at financial loss in there as well.
Okay.
So let me just have a look at the notes on this. Prohibition.
Is it they have a like I don't know, you cover this one. For example, for the distinction grade, there is a 5D1, 2D2.
What? 1 minute. Economic. 5D1.
And 2D2, the last question.
Yeah, they haven't got anything on that. So what, you know, economic loss could be the fact that it could be referred to different than damages or injury of property damage. This is largely because for example, a negligent driver who creates an accident will only cause so much physical harm. Eventually, the cars involved will come to a stop. Economic damage, however, is far less to quantify. And so you'd look at the issue of whether pure economic loss is recoverable or not. So, you know, would they get any sort of loss from this physical damage or negligence?
Okay.
So where an economic loss stems from physical damage to a product or equipment, then it's recoverable. The principle best is understood by looking at the leading case of Spartan. So have a
Okay.
look at the Spartan case in regards to that. And it's all to do with whether they should get any sort of compensation, you know, for economic loss. So if someone's been affected by something, should they get a form of compensation from it or not?
Okay.
And, you know, under the law, you know, you can get economic loss is recoverable using the law of contract. But, you know, there cannot be a claim for loss. So sometimes, you know, you have to be identifying, you know, pure economic loss. And that was identified. Again, the case to use for 2D2 is the case of Donahue and Stevenson in regards to economic loss. So have a look at that.
Okay.
And you've got economic loss, and then you've got the other one, which is pure economic loss. So economic loss may be caused by a natural disaster, such as a hurricane, or by negligence of another party. Pure economic loss is usually defined as financial loss that excludes property damage. In cases of pure economic loss, the only thing that is lost is money. So have a read around that. There's loads of cases, but have a read of Donahue and Stevenson in regards to pure economic loss and economic loss.
Can we claim against the state if that happened?
Yeah, yes, you can. Yeah,
Okay.
yeah.
Okay.
So that's a public authority, isn't it? The state. So you could, yeah. So have a read around recovery of pure economic loss and economic loss and the difference
Yeah,
between it.
I'm mentioning if the person can't get it from the employer, then they
Yeah.
can sue the state. No.
Well, not really, because then they have to get it from the employer. They can't just sue the state for that.
The state for that. Okay.
Yeah, especially if it's a private employer, you know.
But the state have some sort of a compensation scheme or
No,
something?
no,
No.
not like that. That's only in criminal cases, you know, where someone's taking someone to court against things like, you know, these grooming cases, and the state has to compensate that person who's gone through it.
Okay. Okay. Okay.
Okay, so I'll stop sharing that. You have you've got the assignment, and I will email you the notes Just bear in mind that you need to be using the additional resources on Moodle as well. And the notes I send you, they're just for you to have a look at and see if they will support you in completing the assignment. Okay.
Okay, so I just sent you a message of hi.
I'll send you
So
it today. I'll send you them today. Okay.
okay.
Okay then. Farshan, good luck with doing the assignment. Okay.
Okay, thanks a lot for
Excellent.
coming
See you
to me.
later.
Thank you.
Bye.
See you. Bye.